All right, we are now going live. Video. All right, that's me. So we're at the satellite office today. It's lighting and camera angle isn't great, but you get the idea. So my name is Chris Berry, your certified outlaw attorney, certified financial planner. We do these weekly webinars every Wednesday at 1 o'clock, unless I'm traveling or something comes up. And in fact, next week I'll be traveling, so we'll be off next week as well. But we try to do these every Wednesday, and all we do is we log in and answer questions submitted by our clients and people and friends. And if you do have a question, feel free to put it in the Q&A. Happy to answer that as we're going along, or if something's unclear, feel free to put it into the chat as well. And I do have a couple of questions that were submitted already, so I'll get into those. But I always like to start with positive focus, just something positive that happens over the past week or so, or since our last webinar. And I don't think we did one last week. So probably 4th of July. 4th of July weekend was a great time with our family. We couldn't have a more America time. We went to a Tigers game. They ended up winning with my family. So my wife and kids, the kids enjoyed it. We didn't catch a fly ball. We were hoping to, but we were right behind home bench. So that was kind of cool. And then Saturday, grilled up some pork belly burnt ends that were delicious, and went to a barbecue, saw some fireworks. And then Sunday, or the next day, we were out on the lake and we had a big kind of lake party. So it was good weekends, good kind of America 4th of July weekend. So with that, let's go ahead and get started. Again, any information we cover, it's general information. You want to see how this applies to your situation, feel free to schedule some time with us. So the first question, we're married, we set up a trust. Who should be the beneficiaries of the different accounts, spouse or trust? Well, I'm going to give you that lawyer answer. It depends. It depends on what type of account. But like 95 times out of 100, here's how it works. We break accounts into two different types of accounts. We have what we call qualified accounts. And think of this as they have some type of tax qualification. Okay. And this is going to be things like IRAs, so qualified accounts. IRAs, 401ks, 403bs, Roths. So these are all qualified accounts. Some are pre-tax, some are grow tax-free, but they're all tax qualified. So with these types of accounts, typically what we're doing when we're doing a trust is our primary beneficiary is going to be the spouse if we're married. Contingent beneficiary is going to be the trust. The common question is, if I name someone other than the kids as a beneficiary, don't they have to pay all the taxes at once? No. As long as the trust is set up correctly, they still get the full stretch. Meaning they don't have to pay all the taxes at once, but they still get the full stretch, which says that all the taxes have to be paid within 10 years, and that's due to the Secure Act. And that's whether you name an individual other than a spouse, like a kid, as a beneficiary, or you name the trust. But due to the Secure Act, the max stretch you can get is 10 years, whether you name a trust or individual beneficiary. So almost always in our office, if it's a qualified account like an IRA, a 401k, a 403b, 457, Roth account, Roth 401k, Roth IRA, we typically name spouse first so they can do a spousal rollover, and then we name the trust as a contingent beneficiary. Now, the other type of accounts we have are what we call just generally non-qualified accounts. Basically, think of this as everything else, okay? So this would be your post-tax brokerage accounts. We'll throw life insurance in here, checking accounts, savings accounts, money markets, really basically everything else. What we do is we just name the trust as a beneficiary because the trust provides for the spouse and then we'll provide for the kids. So if it's qualified, spouse and trust. If it's non-qualified, basically anything else, we name the trust as a primary beneficiary. Now, if we're setting up an asset protection trust, like a castle trust, then instead of naming the trust as a beneficiary, a lot of times we'll have all this stuff inside of the trust, other than qualified accounts, because they can't go directly into the trust. So non-qualified account, basically anything other than those qualified accounts, name the primary beneficiary of the trust. Again, this is general advice, but I'd say 95 times out of 100, this is what we recommend at the end of the day. And again, the big distinctions here are just qualified versus everything else. IRA, 401k, Roth, 403b, all of those almost always spouse and then trust. So they can do the spousal rollover, and then the beneficiaries or the assets can be protected for the benefit of the beneficiaries. And there's no negative tax consequences in naming the trust as a contingent beneficiary. Yeah, like 95 times out of 100, that's how we do it. And that's a really common question. And so thank you for asking. All right, any questions on that before we get into the next one? All right. Just check. Okay, we're looking good. All right, a lot of these are all trust questions this week. So a lot of estate planning questions. If a couple has a trust in the state docs in Michigan and then moves to Kentucky, are they still valid? Can they be amended? So again, with all of these, like the answer depends, but I would say documents that remain good versus documents that probably should be updated if you're to change states. The trust, that is typically not very state specific. Trusts are transportable. We have a lot of clients that set up like a castle trust or asset protection trust in Michigan, then they move down to Florida. They're all congregating in Fort Myers, like we were joking about opening up the Fort Myers office down in Florida. But a trust you create in one state can own property in different states. So a trust transfers very well. Things that should be updated, probably the biggest one is your medical power of attorney. That one is very state specific. And typically if you're to do a trust, you do a pour over will. So that's probably fine. But what probably should be updated is your financial power of attorney. You know, that one's probably fine too. The big one is the medical power of attorney. This one is a lot of times is very state specific. And then obviously if you buy a new piece of property, you need to update your real estate. But the big portion and kind of the most complicated piece of any estate plan, if you have a trust, is the trust. And then the will is just a pour over will that flows into the trust. So you set up a set of documents in Michigan, then you move to Kentucky or any other state. Especially if you set up an asset protection trust, that asset protection goes to whatever state you are. But even if you have a revocable trust, it's still going to be valid. You don't need to update it. Now, you talk to an attorney in that state, they'll probably tell you, yeah, you should update it. But even when clients move to Michigan, if they have a trust, unless there's a reason to update the trust, typically we're not updating the trust. The big one is the medical power of attorney because that's very state specific. Financial power of attorney typically is okay, but a lot of times we might update that if we're updating the medical power of attorney anyways. But the meat and potatoes of the estate plan, that does not need to be updated if you change. Now that said, can they be updated? The answer is yes. So you can always move to another state and decide to update everything for that other state. And if there's like other legal reasons you're updating the trust, then I might just update it, do a restatement of it, completely update it. Like if you're changing around the order of beneficiaries, that's something that you want to do. That might be a reason to update the trust. But typically if you change states, that's not enough of a reason to update the trust. There has to be some other reasons why we may want to update. Similarly, I had a client ask me today, like, hey, my kids, their address is changing. Do we have to update the documents every time the kid's address changes? The answer is no. It's more of just a convenience type thing. But if we're making other updates to the documents, then we might go ahead and update that as well. So yeah, with the trust, which is the focal point of the estate plan, if you change states, that does not have to be updated just because you change states. Okay. All right. Let me see if we have any questions or comments on that. Nope. Good to go. All right. We'll move on to the last one here. The married couple has a joint trust, then gets divorced. Oops. Joint trust, then gets divorced. What needs to be done with the trust? Well, the first thing is typically with the divorce decree, that's going to revoke the old estate plan. Just had a client call in about this in addition to someone asking this question. So this is fresh in my mind. Typically what's going to happen is you go through that divorce proceeding, especially if it's a joint trust, they're going to say, you know what, we're tossing this aside. And then the assets will be separated. So let's say we have husband and wife, and now husband has these assets, wife has these assets, and through the divorce, they just ensure that there's no like joint assets moving forward. Maybe one spouse gets the house, one spouse gets more money, whatever it may be. Now what should happen, so first is the old stuff will be revoked. Second, each spouse now needs to do their own estate plan. Okay. Which, like, I'll tell you, it's after when I see clients go through divorce, the last thing they want to do is spend any more time with a lawyer, but it is super important to update the estate plan, make sure all the beneficiary designations were in fact changed. Because sometimes we see that as they go through the divorce proceedings, like not all the assets get changed correctly. And again, like you don't want your ex listed as a beneficiary of your accounts. You don't want your ex listed as a financial or medical power of attorney. You don't want your ex listed as a beneficiary. Now, typically through the divorce decree, they'll kind of revoke that, but still you don't want those documents hanging out there. So I know it's tough because if you went through this divorce, you're probably a little gun shy of working with attorneys, but really the next step should be updating that estate plan and getting your own estate plan. Client situation, they got divorced here in Michigan. He's moving down to Florida. I told him to contact an attorney down in Florida, get a Florida estate plan. All right, so a lot of trust questions this week. That is all I have. Again, I'm going to be traveling next week, so no webinar, but we'll be back in the saddle after that. And with that, thank you, everyone. Make it a great week. Take care. Bye-bye.